Hello, and welcome to this episode of Inside Legal ESG. My name is Pamela Cohn, and I'm delighted to serve as the host of this podcast series. Today, we are so fortunate to have with us Julien Beaulieu, a doctoral researcher at Imperial College in London, a lawyer, an economist, and he's also a guest lecturer at the University of Sherbrooke in Quebec, Canada. Welcome, Julien. We're so excited to have you here.
Thank you so much. Thanks so much for inviting me. I really appreciate it. It's a great pleasure, a great honor to be on this podcast.
Thank you. And I recalled earlier this morning that we first met in Paris in April. And
yes,
here
we did.
are again, 6 or 7 months later, having this conversation. So I'm very pleased to have you with us today. Let's start with, how did you come to focus in this area? What brought your career to this point?
Yeah, it's an interesting question. I think like many of us working in this field, I started in a completely different space and then ended up looking at sustainability issues. So I'm from Quebec, Canada. I studied law, completed my MBA at the University of Sherbrooke, where I teach right now. Then I qualified as a lawyer. I didn't know what to do exactly, and I ended up starting to do competition law. So I started my legal practice in a leading business law firm in Montreal with a focus on competition and foreign investment. So at that time, most of my work was to secure regulatory approvals for big mergers and acquisitions. So essentially, it was trying to convince the authorities that a particular transaction did not raise any issues in terms of market share, concentration, or even national security, sometimes in terms of foreign investment. But one of the aspects that we were also dealing with was deceptive marketing. Because in Canada, competition law also deals with deceptive marketing practices. And let's look a little bit into the past, 2018, 2019, firms were increasingly starting to come to see us asking about environmental claims. How could they do environmental claims without breaching the deceptive marketing rules? So they wanted to tell that their products were recyclable, that their products were carbon neutral, and so on. And that's how I got interested in green claims and what ended up being called greenwashing, so the act of making false or misleading environmental claims. And that was very interesting. But then after a few years of practicing law, I started to be increasingly interested in the underlying policy and economic principles underlying competition law. And so I decided that I would go back to school to know more about that, because the law is very helpful to tell you about the state of the world, right? Like you're going to know how our world is structured and what's legal and what's not, but it doesn't really tell you why the things are as they are. So that's why I decided to go study economics in the Netherlands. So I studied Masters of Economics, and that's where I started to be super interested in everything sustainability related, whether it's sustainable finance, policy making, carbon pricing. I was just so interested by all these topics. So I did my master's thesis, and then I started to think, how can I leverage my economic knowledge and my interest for policymaking and my legal knowledge in competition law? And I thought, well, I know a lot about greenwashing, so maybe there's something to be done there. And I started to work with this Quebec NGO called the Quebec Environmental Law Center, which for those of you who don't know the Quebec Environmental Law Center, it's a bit similar to Client Earth in the UK. So a nonprofit that helps citizens take legal action and provide advice. And so at the time, there were several NGOs that were starting to file greenwashing complaints. So they were flagging cases of potentially misleading claims, and they were bringing them to the attention of the regulator. And this was a very interesting phenomenon. It's like a great way to seek accountability. But on the other hand, it was a little bit like a cat chasing a mouse. And you have to do it over and over again, trying to find who are the greenwashers and who's lying, and this doesn't end, right? Every day there's new claims being made, and so we thought, okay, how can we have a more systemic approach? How can we really look at this problem with a deeper look? And so we decided that we would do a research project on this topic and come up with policy proposals for legal reform. And this was a very timely project because a few months after publishing our report, the government announced a big consultation on reforming the Competition Act. And fast forward in time, last summer, changes were adopted to reform the Competition Act. So this work that started, in legal practice and then eventually through the master's thesis and then collaborating with NGOs, it led to concrete legal reform. And now we have this Reformed Act that explicitly deals with greenwashing. So I'm personally very happy about that. And then, of course, then other things started to add up. I started to teach, as you mentioned, competition law and corporate social responsibility in Sherbrooke, and also started to work with professors in other universities on greenwashing, on science denialism, on climate litigation with people at LSE, University of Michigan, Western University in Canada, and I was like, okay, well, I like to do research, I like to do impactful work as well, and I like to teach. Seems like academia is just the perfect career, so why not continue to the PhD and then try to make it into academia?
So tell me a little bit about the research you're doing now as part of your PhD.
Yeah, so still on greenwashing and climate litigation, I'm going to be looking actually at two types of climate lawsuits. I would really want to combine economics, environmental policy, and law. So first, I want to focus on greenwashing. What type of policies are effective to deal with greenwashing? Is it deceptive marketing rules? Is it certification schemes? Mandatory disclosure of information? What works? How can you compare these different policies? And also empirically, how can you measure the effects of greenwashing? How can you identify it? So that's one angle, and the other angle is a very it's an up and coming field, developing. We don't have too much evidence on this yet because most of the cases are still in the early stages, but it's compensation litigation. So organizations, citizens, groups that are suing companies, states, any stakeholder for the damages of climate change. So trying to, after a flood, after a hurricane, try to get money to compensate for the damages, or in anticipation of future damages, already seeking money to prevent damages from climate change, to build a dam, to build more robust infrastructure, these types of things. So this is emerging. We've seen a few cases in the US. There's a high-profile case in Germany right now, but I think that we're going to see more of these cases as, unfortunately, climate change starts to be more visible.
Mm-hmm. It was just a few weeks ago, we're recording this in mid-October. It was just a few weeks ago that Canada announced some new climate disclosure regulations for even private firms, not just listed firms. Tell me more about that.
Yeah, it's very interesting, the development. So of course, it's interesting to me as a North American lawyer. Maybe the folks in Europe won't find that so innovative. Maybe they're gonna say, Canada, you're 10 years behind. Fair enough. That's a fair comment, but there's still changes, so that's something to be hopeful about. When we look at greenwashing, Canada has three big building blocks to prevent greenwashing. There's these deceptive marketing rules. The Competition Act is one of them, saying you cannot lie. When you make claims, you should not be lying. But then that only applies to the people who decide to voluntarily speak, right? So if you don't speak, then you're not covered by that. So that's where the second building block comes, and that's what was announced a few days ago. It's climate disclosure. So then this is not just applying to the people who decide to voluntarily speak, it's forcing everyone to report information. And so what the federal government announced is that it's similar to the CSRD in Europe, every private firm of a certain size is going to have to make climate-related disclosures. So that's a very second interesting block. And the third one is taxonomy. Again, still already exists in Europe, but Canada is a resource-intensive country, big fossil fuel producer. So these things are more controversial. These are tough political decisions to adopt a taxonomy. Are we going to include a transition category for oil and gas or not? That's why it took so much time. But now we're about to see the taxonomy. The government announced that it would go ahead. And this is essentially creating labels for which projects will be green and which projects will be transition. So then we have these three pillars. We're saying you cannot lie, you must disclose information, and here we're defining some terms for you so that you can use these terms to develop investment funds, financial products, and so that everybody plays by the same definitions. We all know what green means. We all know what transition means. And so we're really creating we're leveling the playing field essentially. So positive developments. Let's hope that they're gonna evolve over the next few weeks.
And so what is the implementation date of those regs? When do companies have to start doing these disclosures, for instance?
So we don't know yet. The government
Okay.
announced that it was moving ahead, but the thing is that they still need to work with provinces to make sure that every company is going to be covered by these things. Because now it would only apply to, it's a little bit technical, but Canada is a federation. Companies can be either constituted at the federal level or at the provincial level, which would be equivalent to the state level
Yes.
in the US. And therefore, Canada can only create these regs for federal corporations, and then they need to discuss with the provinces to make sure that every company is required to report information. Now it won't be perfect, right? Like this is only on climate risk. So now we'll also need something on biodiversity, on extraction of resources, and we'll also need something on impact, because this is only about risks and opportunities. So it's not following a double materiality approach, and that's something we're going to be really pushing hard with the NGO I'm collaborating with, trying to incentivize the government to go even further beyond climate risks, because I think there's all these impact investors and also just concerned citizens and consumers that also want to know about impact, not just about risks and opportunities.
And, so many companies in the US and in Canada already fall under the threshold of the CSRD if they're doing business in Europe. And so, probably by the time Canada gets to double materiality, companies will already be doing it. And I would say the same thing for the US. The
You're
EU
so right.
are really driving it.
You are so right, and this is an additional argument. So there's this idea that yes, the compliance costs will not be that high because certain companies will be already disclosing this information because they will be required to do it. California also has these scope 3 emissions. Well, now it's the state. We'll see also how that evolves in the future.
Okay.
But there's all these jurisdictions that adopt these international, these national or continental requirements that will end up having international effects. And on top of that, there's also a question of international competitiveness. If certain companies of a particular area provide a lot of information and highly credible information to investors, then capital is going to go towards these jurisdictions. So we also don't want to be in a world where Canadian companies or US companies are not trusted as much or don't disclose as much information, or when they disclose information, it's in an inconsistent format, and then it's very hard to use this information, and it doesn't get reflected in high ESG ratings, it doesn't get incorporated in the investment policies and so on. So there's also this question of competitiveness and making sure that our companies get the rewards for their investments. And that's just economics, right? Like just capital markets as they've always worked. There's nothing new about that.
So let's stay with Canada regs for a little bit. There's also the Bill C-59. Tell me about that.
Yes, so that's the one I was mentioning earlier. So we had been asking. So there was this game of of cat and mouse, right, between NGOs who were filing complaints and trying to police environmental claims in the marketplace, reporting them to the Federal Consumer Protection Agency, the Competition Bureau. And one of the big issues about that, a big issue, was that the Bureau, when they would take on a complaint and decide to file a claim before the tribunal, they would have to prove that the information was false or misleading. But that's very difficult, because let's say you have a project. Let's just imagine some industrial project, and the promoter says this project is going to be carbon neutral. Well, that might be true, that might be false. Maybe the promoter has very good data, they've done their homework, it's very credible. But for the Bureau to prove that this claim is false, they need a lot of evidence, they need a lot of expertise, right? And it can be very time consuming to build the proof, to demonstrate that something is false or misleading. So that was complicating the proof of these greenwashing cases. And so the changes, essentially what they're doing is that they're requiring organizations that make environmental claims to have proof. So we're shifting the burden of proof, and now it's on companies' shoulders. Companies are required to have evidence whenever they make a green claim. And therefore, if there's a complaint and the Bureau decides that they're going to file a lawsuit, then the company has the responsibility to show the data, to show the evidence. And then if the evidence is proper, it's adequate and proper, then there's no problem. But if they cannot show the evidence, then already that's breaching the law. And so this is something we didn't have before. We had it for certain product performance claims, but it was not super clear if it applied to all environmental claims. So now it's broader. And there's a complementary change that comes with that, which is private access to the competition tribunal, which essentially will allow private companies, so competitors, for instance, but also civil society groups to directly go before the tribunal to file lawsuits against greenwashing firms. So essentially, it's an access to justice move. It's just going to potentially increase the frequency of these lawsuits, and it's facilitating the access to the tribunal, which is also something that did not exist before.
So one of the things we chatted about when we met for a cup of coffee in Paris in April was how greenwashing claims, how regs, how does that intersect with freedom of speech?
That's a very good question. No,
I remember that conversation.
Yeah, it's such an interesting one, and I mean, this has been all over the news in Canada all summer, essentially, because so now with these changes, we're requiring companies to have evidence, right? So you cannot say something unless you have evidence to prove it. Which seems pretty basic. Like you would assume that if you make a technical claim, you should always have evidence. You should not be just speculating about what your product or your company is doing. But still, there's some restriction on what you can say. You cannot say something unless you have proof. So there is some restriction on your ability to say things. Now, that has been so some stakeholders, is mainly from particular industries, have said that this was really harmful for freedom of speech, that we were preventing companies from advertising what they do well, and that this was a very slippery slope, because now a government was preventing companies from speaking about what they do, and this could harm innovation. It could reduce the quantity of information available out there, this greenwashing phenomenon. I don't buy into that as much. I think we've done it several times in the past, restricting freedom of speech in very limited way, very specific targeted ways to ensure that the information out there would be more credible, would be more transparent. Tobacco regulation is one example. We've done it. Now, with these changes, we're not preventing companies from saying that they're green. They just need to have evidence to prove it.
That's right. That's right.
And for me, that's a pretty low.
It just has to be true.
Exactly. And there's been several constitutional challenges in the past that have tried to argue that the Competition Act's deceptive marketing provisions are breaching the freedom of speech. This has happened, and we've seen there's ongoing cases in the U.S. Arguing very similar things. But the act has always been maintained. All these challenges, none of them has been successful, for this very specific reason that these are pretty limited restrictions on freedom of speech. So yeah, you can still say something if it's true. You can still say something if you have evidence. In my opinion, it's not a big issue. But of course, I can understand that some people got scared. They were a bit worried that this would create new risks, and it's important that the Competition Bureau provides guidance, or that the government adopts some regulation to say, well, here's what we mean when we say evidence. It means a report audited by a firm, or it means compliance with SBTI or with the GHG protocol in terms of emissions accounting, providing some more certainty. That's something that's possible.
So tell me what you think is in store for you, and also for the areas that you work in, for the remainder of 2024, but also sort of into 2025. Like if we were going to meet again a year from now, what would we be talking about? What's on the horizon?
Yeah, it's interesting. I think we're going to see additional cases of greenwashing. In Canada, these new provisions haven't been tested before the courts, so we're going to see if somebody brings the first case, and then we're going to get more legal certainty on what these things actually mean. Now, in Canada, there's elections, so that's also going to lead to potentially significant policy changes, legal changes as well, if there's a change in government. So we'll see what happens on that side. But another area that I think we should have our eye on is all these compensation cases. So I said it earlier, this is a new field. There's not been many of these cases that have reached the end of the legal process, of the adjudication process. So probably in the next year or so, we're gonna get some decisions on these cases, and we're gonna know with how all the new developments, scientific developments around attribution science, how they get factored in by the courts, and whether we can use these things as evidence. And this can open the gates, right? Like if there's some cases that move forward and there's some companies that have been major historical emitters of greenhouse gases that are asked to compensate people, hurricane victims, for instance, for the damages of climate change, that could lead to so many additional cases, and then that raises all sort of very interesting questions in terms of, who's actually liable, who's responsible, and financially, what does this mean for the economy? So I think that's something to keep an eye on.
So one of my favorite questions to ask all of my podcast guests before we have to wrap it up is, given all the challenges that those of us who work in this space face every day, what gives you hope? What gives you enough hope to keep working?
I think is that we're seeing positive changes every day, like with these greenwashing changes, for instance. This has worked. We did research, it led to changes, and now we have an improved regulatory scheme. And I think it's true for several fields that we're finding out new things, we're implementing new policy. It's going to take some time to see results, and of course, we're not moving fast enough. 100% sure about that, but we're still seeing some changes, and I think this is very promising.
Well, I tend to agree with you. And also what gives me hope is people like you who are working so hard in this space and doing good research. I'll be looking forward to seeing your research as you publish during your PhD studies. So thank you so much for joining us, Julien. We really enjoyed the conversation.
Thanks to you. It was really a great honor. Thank you so much.